come before us is NRA, BT, and CT, and I just want to remind the attorneys of some ground rules here. We are going to be videotaping this, and this will be appearing on Facebook. So please stand behind a podium, keep your voice up, and also please do not mention the names of any children, and just refer to them as a child or minor or whatever, but do not mention the names of children. So we have read the briefs and we're ready to proceed. Each side will have 15 minutes. The appellant may reserve up to 5 minutes. Ready to proceed. And we have the monitor over there that shows your time if you so desire to use it.
Thank you, Your Honor. May it please the court, Attorney Steve Gretchen with the Law Office of Kim and Associates, on behalf of Mother Brooklyn McGuire. I was court appointed to Ms. McGuire, the underlying trial level of this case, and proceeded to adjudication on November 9th, 2022. And this is on appeal from the Summit County Juvenile Court on the finding that the minor children in this case were adjudicated to be dependent under the law. This finding of dependency was clearly against the manifest weight of the evidence. So we would ask that you reverse on that. In the alternative, and then reference to minor CT only, the newborn child, we ask that you reverse and dismiss without prejudice for the failure to hold a dispositional hearing within 30 days of adjudication. So the basis for this appeal is that Nurse Robin Rep was not qualified as an expert to give testimony as to medical diagnosis under the law.
Well, she's a nurse practitioner, correct?
Yeah, she is a certified nurse practitioner.
Was there anything on the record where she talks about her qualifications about being able to give diagnoses or getting that specific diagnosis?
No, in my opinion, in the reading of the transcript, the state did not present her CV, they did not make it an exhibit, they did not qualify her as an expert under Evidence Rule 702. She did not give a basis for her opinion or why she holds that opinion, and she did not go over why she was qualified to give that opinion, and the court did not find her to be an expert, did not give any ruling that she was being held out to be an expert under Rule 702.
Is there any testimony that she was just regurgitating a diagnosis already made by the doctor?
No, that's why I usually object to the records coming in, and you can see in the transcript I do not object to the records coming in because the records do not indicate a diagnosis of neonatal abstinence syndrome, which I'll refer to as NAS for the remainder of my argument. There's no diagnosis of NAS. There is concern and symptoms for NAS. Nurse Ball, who testifies before Nurse Rep, who's an RN, she confirms this. She confirms any diagnosis of NAS is reserved for a medical doctor. She confirms that there is no diagnosis of NAS in the medical record, that only mere symptoms of NAS that they had a concern for. See, normally these newborns, when they have these types of issues, have a whole slew of issues, and that's why they're in the NICU. This child had no issues. This was a completely healthy baby. This baby was over 40 weeks, had an APGAR score of 1 minute of 8, 5-minute APGAR score of 9, was over 40 weeks. This was no indication this baby had any exposure to prenatal drug use.
Well, in those medical records, though, isn't it a fact that the medical records demonstrate that the child was prescribed morphine?
Yes.
Okay, so one of two things: either there was something wrong with the baby, or the hospital could have malpractice, and the doctors.
Possibly. It was prescribed as a precaution. They could have easily tested this baby for, do a toxicology screen on this child, and they refused to do so. If they would have done a toxicology screen on this child, we may not be here today, because we would have a definitive answer whether or not the child was exposed prenatally to opioids.
And there's nothing in the record that indicates that mom took any type of drug testing, correct?
No, mother did refuse a drug test once
She refused it, but there's no other thing in the record. Will we find anything in the record about any type of drug use by mom?
No,
other than refusal?
no, just the, I don't know if that's in the medical record, but it's in the transcript, that's, they called CSB, and CSB requested a drug test, and she refused to take a drug test. She reported that she was sober for 2 years, and she did not understand why they were questioning her, and why that she needed to take a drug test.
Let me ask you this, did mom have to give permission for the child to be drug tested?
No,
And why would that be?
because they immediately filed for temporary custody of the child, and they could have made that decision. They could have ordered that drug test even after the fact. May have still had traces of opioids, if opioids were in the child, which I argue there were not.
So before they filed, well, the answer to the question is then, I guess, it would have to be court ordered to get the child drug tested.
I don't think it would have to be court ordered. Once the emergency temporary custody was granted to Summit County Children's Services at the emergency shelter care hearing, they would have immediately have the right to do that.
Thank you.
But the ultimate issue is permitting her to testify was a clear error of law. It's not harmless error. And again, it's the only basis for their dependency is this was a completely healthy and normal child. Page 4 of the brief, which goes into page 42 and 43 of the transcript, that's the heart of the issue. And that's when I asked, it's direct, and the prosecutor asks Nurse Rep, during your treatment of the newborn, were you able to find any other possible medical reason why he was exhibiting these symptoms? And her answer was no. And I immediately objected and moved to strike that answer, where I argue she is not qualified to give medical diagnosis as a nurse. That, not only is she testifying to the medical diagnosis and that she is ruling out any other possible explanation for the symptoms of the child, she is giving above and beyond what her training, education, experience allows. That's for a medical doctor. And the symptoms they're referring to is it's the newborn was having disorganized feedings, he wasn't sleeping, he had, some fast breathing, he was irritable. I don't know what newborn doesn't have some irritability and is not sleeping through the night. Based on those just minor symptoms, they immediately jumped to the fact that this child was exposed to opioids in pregnancy with no other evidence. The magistrate allowed it in, and the judge allowed it in. This is referenced in the magistrate's decision where he says, Ms. Rep offered that in her professional experience she was unable to discern any other possible medical reason for the newborn symptoms and behaviors other than NAS. So that is their basis for adjudicating both minor children as dependent. And then in the judge's order denying my objection, the trial court also writes, the court first notes that based upon the above ruling as to the testimony of Ms. Rep, the court will consider all of the testimony presented at the November 9, 2022 adjudicatory hearing when considering mother's objection. And the reason the court has to take her entire testimony into consideration in overruling my objection to the magistrate's decision is there is no other evidence that this child was experienced withdrawal symptoms other than this nurse's testimony.
Well,
That was
Nurse practitioner.
Nurse practitioner.
There are different statutes for nurses and nurse practitioners and when their testimony can come in, is there not?
I would say yes, as to the case law cited by the state, which does not make it to the level of medical diagnosis.
And
It's
also-
physical condition.
There
There's a difference between physical condition and medical diagnosis.
And you're saying there's no foundation here either.
And they didn't give any foundation, even present her as an expert, and I even pulled their pretrial statement where they list potential witnesses, and then they have expert witnesses at the bottom, and they don't list experts, they just cite 702 and 701. I don't know if it's because it's bolded, they were naming the nurse as an expert, but there is no foundation, no CV as an exhibit, as you see, just the records. She was the treating nurse, and they were bringing her as a fact witness, but then they could testify to what's in the record and their treatment of the child, the symptoms that the child was exhibiting, but they took it because they did not have the requisite clear and convincing evidence, in my opinion, they took it to that next step, that there was no other explanation for these symptoms, when there's a whole slew of explanation for the symptoms the child was exhibiting, other than exposure to opioids during pregnancy. In the case law and the statutes, I mean, the case law I cited to the statute, medical diagnoses are by a nurse is specifically prohibited by statute. It's prohibited by several cases, even cited by this court. And then also the fact of the cases that the state relies on goes to physical condition. The one case in particular, I believe State versus Hall, in that case, a doctor testified. And the doctor testified to the main child's diagnosis of PTSD. The nurse practitioner, Nurse Abbott, testified in that case as well. She did not testify to the medical diagnosis of PTSD in the child because she is not competent or qualified to give that medical diagnosis testimony. She merely testified to the physical conditions and symptoms that she witnessed that led to the diagnosis, which is not, that the child was sexually abused. That's not the medical diagnosis of PTSD. She testified, I think this child was sexually abused.
I'm trying not to interrupt you, but I want you to know that you're under 5 minutes. Do you want to reserve any time? I don't think you told me you wanted to reserve time, but.
I'm almost finished, so I'll reserve maybe 2 minutes.
Okay.
And the same thing, the other case they say too, ironically, it's the same nurse, the Nurse Abbott, who's a certified nurse practitioner. No one objected to or challenged her credentials or her experience in that case. And that, again, she testified to physical condition of sexual abuse, not a medical diagnosis. I think the most important distinction is in State versus Hall. If the nurse is qualified and can testify to medical diagnosis, she would have testified to the medical diagnosis of PTSD. She only testifies to, as the case states, to the physical condition of the child. I'm not objecting to nurse rep testifying to the physical condition of the child. I'm objecting to the fact that she took it to the level of not only was he diagnosed with NAS, which is not on the record, that she says there's no other possible medical diagnosis in the history of medicine that this child could have, which she did that just to get clear and convincing evidence. Because without that statement, the state does not have clear and convincing evidence given this is a healthy baby. The only reason this baby was moved to the NICU is he was vomiting green mucus, a green vomit. Normally these childs are underweight, very sick, and go to the NICU, and then that's why they're diagnosed with being exposed to opioids. This child is vomiting green mucus, which could be a medical emergency, which could be a bowel obstruction, so they worked the baby up immediately. Baby did not have a bowel obstruction, and they never found a cause of the green mucus, and it just went away. And while the baby was in the NICU, for whatever reason, they say, I want to drug test the mother. And they had no basis or reasoning for that. The baby just was irritable, had disorganized feedings, was not sleeping at night. Those are not uncommon things for a newborn. I do not understand where the jump immediately to, I want mom to take a drug test and then remove custody. I mean, that's what we're here about. They took this mother's child with no evidence. No evidence. And they can't cite one case that even gives this nurse that authority to testify that way. So I'll reserve my 2 minutes.
Thank you.
Good morning, Your Honors.
Good morning.
Meredith Hannah on behalf of Senate Women's Children's Services this morning. I have a different view of the record from Mother's Council and Mother, and I believe that the court did below as well. I think the record is rife with evidence supporting the finding. There's clearly clear and convincing evidence to support the dependency finding. This isn't a situation where a baby was just for no reason moved to the NICU at the hospital. And if you review the transcripts and it's set forth in the magistrate and the judge's order, it clearly details every step that was taken to find out what was going on with this child. And what the theme here seems to be is that the mother has put up roadblocks every step of the way to prohibit the state or Children's Services from taking the correct actions or the best actions.
By roadblock, do you mean that she refused to take a drug test?
She refused to take a drug test. She denied that there was ever any drug use. She indicated that she had been a drug user previously, but was no longer a drug user. Denied anything about the other minor child, BT. She denied that that child had been removed. She indicated to the social worker that BT was living with his father only on the weekends, that she had custody of the child, which was not true. She was appearing to be in a state of denial, appearing to need help, and it does appear from the record that there were efforts made to work with her so that these children would not have to be removed, that there would not have to be such a finding. But to come in here and say that this record contains no evidence of this child suffering when he's in NICU, just because he was full term, just because he was a normal weight, does not mean that he wasn't also exposed to drugs in utero.
Well, counsel, I don't know that he's saying that the child didn't suffer. He's saying you didn't present the requisite evidence to prove what caused the suffering.
Well, Your Honor, I understand and appreciate that. What I find telling is that Nurse Ball testified without objection to essentially the same thing that Nurse Ref testified to. And in Nurse Ref, or certified nurse practitioner, I'm sorry I got in the scheme of calling her a nurse when she actually is a certified nurse practitioner, she was actually qualified. She did testify as to her credentials, and in cross-examination, I believe that counsel for mother elicited that testimony further, which is also attached to his brief in the objections to the magistrate's opinion or decision. You can see where he actually elicits that testimony that she is qualified to offer a diagnosis.
I have a question. You have medical records in the record, correct?
Yes.
Is her diagnosis she makes in court part of those medical records?
She indicates at one point in the testimony, and I wish I could pull out the specific page, but I can't. She does indicate that was already in the record. I believe that was on cross-examination with mother's counsel. She indicated that she didn't make the diagnosis, that the doctor had made the diagnosis, and she was
So we'll have to
simply...
check that out because that is an inconsistency here. Is it, I guess we'll have to look at the record closely because I can't, counsel for appellant says that that is not diagnosed in the record.
I believe that it is.
Okay.
There's a lot of records. I believe there's testimony on the record to support that there was a diagnosis. Nurse Ref, or certified nurse practitioner Ref, had firsthand knowledge of what she was testifying to, and she worked in conjunction with the doctor. Again, this child wasn't just in the newborn nursery. I can't think any hospital would just simply take a child from the newborn nursery, put it in the NICU, and decide that they were going to give it morphine because it was irritable. This is a situation where the trial court looked at everything. The other child that was removed, those records were also admitted. The medical records, the testimony of Nurse Ball, Nurse Ref. In addition, there was testimony at one point, I know Your Honor had asked a question about drug use. I'm not exactly sure, I believe. Other drug use. And again, this is one of those things, I can't remember the exact page, but there was testimony, and it occurred afterwards. She did finally submit to a drug test, and the tester contacted the caseworker to indicate that the level of drug that was in her system was indicative of someone who was a heavy user. It wasn't something that was a one-time thing. So at that point, that testimony, which was also in front of the trial court, harkens back to the fact that this is something that is a long-term issue with the mother, and that the state took steps to protect the child.
You indicated in testimony that Nurse Rapp stated that this diagnosis was based on doctor's diagnosis in the part of her rounding or something to that effect, if I recall.
I believe, I'm sorry,
No, go ahead.
I believe her exact words were, "It's in there."
Well, I guess my question is, did she make this diagnosis from the record, or is this something that was diagnosed by the doctor? Do you know?
I don't know that. I wish I did, I don't know that. I believe that she testified that it was in there, and I know that she did work in conjunction with the doctor, that this wasn't something she was out there on her own, although within her expertise, she would have the ability as a primary caregiver to do that, but she indicated that she worked in conjunction with Dr. Cotain, that she had reviewed the notes that were there before, and that they took these steps because they had ruled out every other option. Now, whether a hospital has to go through and rule out every possible option for an agency to go forth with a dependency action for that trial court to find clear and convincing evidence is not something that we can address here. We don't have to. We know that the hospital, that the nurses, that the staff took steps to ease this child's suffering, and that the child was in NICU.
But the child was moved to NICU initially because of the vomiting and the brain mucus.
I believe it was not just because of the vomiting, and that was an issue, and they feared bowel obstruction, and actually sent the child for further testing to rule that issue out. He was jittery, sneezing, which on the surface may sound like it's nothing, but for trained professionals who deal with these children, they were aware that this was something that could indicate drug use in utero and withdrawal symptoms. The tensity of the child, the tightness, the fever, there's a fever, the vomiting, the inability to control his muscles in order to feed was a problem. So these steps needed to be taken to ensure that the child could thrive. The child was not thriving, and they did the best they could under the circumstances, but not having the mother's drug test, and I believe, questioning myself here, but I believe that there is evidence in the record that the mother refused to allow them to do a drug screen on the child, a tox screen, and that there were conversations with her about their desire to treat the baby. So it appears the mother was concerned about getting herself in trouble, although she said she wanted the best for the child. She wasn't taking the best for the child because she wasn't being truthful with respect to what had happened before. There are cases where parents have used drugs, and they have told the caseworkers that they have used drugs to allow the child to be properly treated by the physician. But in that case, in VR especially, which a mother relies upon, there was not any impact on the child. The impact is clear here. There's no question this child was impacted. The extent of the impact, he's in NICU. So we'd ask the court affirm the lower court's decision and find for children's services with respect to the dependency in English.
Thank you.
Thank you.
We have some time, but do you have any commentary on the 30-day requirement? Counsel?
Counsel,
Counsel, there are two assignments of error in this case. You addressed the first.
Oh, I'm sorry. I'm sorry.
You have some time.
I'm deaf in
You
this
have some
ear. I
time.
thought you were
It's okay.
talking to him.
No, you have some time left. You did not address assignment of error number 2.
We believe that the mother waived any issue, invited the error, and that there was good cause shown. Sorry, so embarrassed. That the mother waived that issue, invited it, and that there was good cause found below for that extension, and it was still done within the 45-day time frame.
thank you.
Thank you.
You have your 2 minutes.
Thank you, Your Honor. Mother refusing a drug test was her right. She reported being 2 years sober. And that's not a roadblock, that's a right. And with that being said, the state knew exactly what they were doing. They subpoenaed Dr. Protein to appear on November 9th. The doctor didn't show up. They were out of time under the deadlines to have a continuance, so we went forward with the hearing. So they knew exactly what they were doing, because that is the very last question that I object to of Nurse Rep that they asked on her direct examination. Because every question leading up to that, and in the testimony of Nurse Ball, they did not have the requisite proof for clear and convincing evidence. The only requisite proof that they presented to the court was that one statement, which is a blatant violation of the law. She was not qualified to give that opinion. And I did not delay the dispositional hearing or waive my argument that it wasn't held within 30 days. When I showed up 9 days later for the dispositional hearing, we didn't have an order yet on how the adjudication was going to be ruled on. And it was my position that adjudication was not going to be found for dependency, and I thought the case was going to be dismissed, because that's what I'm asking this court to do. If you look at the docket, the order for the adjudication is actually dated 22 minutes after the start of the dispositional hearing that I asked for a continuance for, because they did not even have an order in time. And my client has rights. And sorry, my clock's not ticking. And referring to Nurse Ball, she's the one who gave me all those things. She's the one that says opioid withdrawal in children, that they are normally not full term. They are normally underweight. They have low APGAR scores. She's the one that admits all those. And she's the one that actually says that the records state there are, quote, symptoms of NAS. They had possibility of NAS. They had concerns for NAS. And she agrees that it's for a medical doctor to make that diagnosis. That diagnosis was never made in this case. And then after a 10-minute
Counsel, you're out of time.
Thank you.
Thank you. We will take the matter under advisement, and we'll review everything, issue a written opinion that will be sent to both sides, and will also be released on the Ohio Supreme Court website. Thank you very much.